for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-5056, Wisconsin Voters Alliance et al. Versus Kamala Harris, Vice President, in her official capacity as President of the United States Senate et al., Eric G. Cardall, and Morman, Cardall, and Erickson, PA, appellants. Ms. Shore for the appellant, Mr. Echemendy, amicus curiae.
Good morning. Good morning.
Good morning, Your Honors. May it please the court. I'm Channing Shore. I'm here representing the appellants Eric Cardall, Morman, Cardall, Erickson, PA. My client, Eric Cardall, is here with me today in the courtroom. At the outset, I would like to set forth what we agree upon with the amicus in this case. First, Eric Cardall has standing to maintain this appeal. Second, Mr. Cardall suffered an injury in fact as a result of the district court's February 19th, 2020 order, which I will refer to today as the order. Third, this court's determination that the district court acted unlawfully with the order would, as set forth by my colleague at page 31 of the amicus brief, at least partially redress Mr. Cardall's reputational injury by removing the order's legitimate force. And fourth, in the order, the district court stated it would, quote, refer the matter to the committee via separate letter, end quote. This referral letter, if sent, is not part of the record and is not before the court today.
But just out of curiosity, has the letter been sent?
Sir, Your Honor, I couldn't hear you.
Oh, I'm sorry. Just out of curiosity, has the letter been sent?
Your Honor,
You know?
I can only speak to what's in the record, and the letter is not in the record, Your Honor.
So you don't know whether it's been sent, or you don't know whether the disciplinary proceedings are ongoing or anything?
It's not part of the record, Your Honor.
Okay, all right.
So you're basing your argument here today on the statement that Judge Boasberg made in his opinion that he was going to refer?
Respectfully, no, Your Honor. This appeal is not about the referral to the Committee on Grievances. This appeal is about the order in full, which did more. There's a statement in the order that says that the court will refer Mr. Cardall to the Committee on Grievances via separate letter. But then it goes on for 4 pages to address the substance of plaintiff's counsel's response to the show cause order.
Doesn't he also say, I'm not making a decision about this? Here are the facts. I assume that's the part of the order that you are referring to, where he says, the reasons why I'm sending this referral are X, Y, Z. These are the facts that I've observed, but I'm not making a decision. I'm sending it to the Committee on Grievances. Do I misread the letter to say that, or the order?
Correct, Your Honor. The order does say that, but the issue with the order is that there's a local procedure for how the district court can refer cases to the Committee on Grievances. The district court ordered Mr. Cardall and plaintiff's counsel to show cause why they should not be referred to the committee. They then submitted a 13-page response, which is at appendix page number 1840 to 1852, which included an 8-page expert opinion declaration from expert Richard Driscoll in support of Mr. Cardall's conduct, saying that it did not violate Rule 3.1 of the Rules of Professional Conduct.
Did Judge Boasberg make the decision that it did violate the Rules of Professional Conduct?
No, Your Honor.
All right. So keep going. I mean, those things are in the record, and Judge Boasberg found that your client had discharged his duty insofar as he responded to the order to show cause. But as far as I understood, Judge Boasberg never made any findings with respect to the issue of whether your client had violated the rules of professional conduct or anything else.
Your Honor, the abuse of discretion comes from Judge the district court's failure to address the substance of the arguments that were presented, which
Ms. Shore,
include...
before you get to abuse of discretion, you have to establish this court's jurisdiction.
Yes, Your Honor.
So would you focus on the question of finality, please?
I'm sorry, I didn't catch the last.
Would you please focus on the question of finality? Is this a final order that's appealable to this court?
Yes, Your Honor.
And why?
This is a final order that's appealable to this court. First of all, it's the last docket entry that's noted on the docket.
Why does that make a difference?
Because this order adjudicated the plaintiff counsel's response to the order to show cause. After the case had been voluntarily dismissed by the plaintiffs,
So take your standard administrative case. We have thousands of them. The amicus points out that in all of these administrative cases where you have an agency that initiates proceedings against an entity, say a corporation, makes a judgment that there's a reasonable basis to think there's been a violation of the law. We in the Supreme Court have held for decades that that's not appealable. It's not a final order. And to be honest, I just don't see how this is any different from that. You've got a district judge here basically referring a matter for further administrative proceedings, in this case, disciplinary proceedings. And as Judge Jackson points out, in your average administrative case, the agencies are making a judgment that there's a reasonable basis to think the law was violated. Here, you don't even have that.
Your Honor, respectfully, the order does not simply refer Mr. Cardall to the Committee on Grievances. It goes further, and it sets forth the allegations of misconduct,
right,
which, per the local rules, are to be sent via separate letter,
right,
because there's a confidentiality process until disciplinary proceedings have been investigated and determined to institute a formal investigation. It's confidential. The district court's grievances with Mr. Cardall and his evaluation of the 4 points in the order violates that process.
But only insofar as you've chosen not to figure out whether there was a separate letter and put that in the record. I mean, Judge Tatel asked you at the beginning, was there another letter? Was the process followed? And you say that's not in this record. But I don't see how then we can determine whether the district court did or did not comply unless we know the facts about whether the letter really went out.
Respectfully, that's the issue. The issue is the order says that it's going to be referred by a separate letter, but then it doesn't conclude there. The order then goes on and states the grievances on the public record.
States what on the public? All it states on the public record is that your client didn't satisfy his show cause obligations. That's all it says.
Well, it goes a little bit further than that, respectfully, Your Honor. There's 4 issues and 4 pages of text that the district court disagreed with in plaintiff counsel response. And notably absent from the explanation is the fact that there's a supporting expert opinion that Mr. Cardall's conduct in the underlying litigation complied with Rule 3.1 of the Rules of Professional Conduct.
What if that's in the letter that we don't have here? What if that's in the letter? No abuse of discretion then?
Respectfully, this appeal is not from the referral to the Committee on Grievances. That letter is not what's on appeal. The order, which is more than just a statement within the order that it's going to be referred. The statement that there's 4 pages of argument and allegations of misconduct against Mr. Cardall that fails to address the substance of Mr. Cardall's response.
Right. So I might be mishearing you, but you keep saying that there are things missing from the order. It doesn't refer to the expert report. It doesn't talk about what you just said, And I guess what I'm asking you is, since we don't have the letter and both the order and you and the rules contemplate that there will be a letter, what if the district court's order was just the few little summary points, but there's a letter out there somewhere in which he actually does all the things that you're talking about? I don't think you can, as a matter of procedure, under those circumstances, not give us the letter, focus only on the order, and say that the district court did not comply with his obligation.
Respectfully, Your Honor, the letter that it would have instituted if sent the disciplinary process. The order that's on appeal concluded the underlying litigation. That's what the issue is before this court. And that order.
If you divorce, can you all hear me okay?
Yes.
Yes.
Uh-huh.
If you divorce the, you try to divorce this entirely from the referral, seems to me pretty artificial, because your case for finality rests on the district court wrapping up the underlying case on the merits. And in that sense, it looks like he's approaching the point of finality. But I mean, if the district court had made all of these very highly critical statements in an order just granting a motion to dismiss by the defendants in the underlying case, this wouldn't even arguably be appealable by the lawyer, right?
To repeat your question to make sure I understand, if this order were at the stage of the...
He says, let's just take, the order that you're trying to appeal says to wait as counsel did smacks once again of political gamesmanship, okay? It's a very highly critical statement, and let's assume I think that comes close enough to saying that he violated the rules, which big assumption. But even if I think that, I mean, if that statement had been made in an order dismissing the underlying case on the merits, it would just be a judicial opinion that criticizes how a lawyer handled the case, which happens all the time. And lawyers don't get to appeal those decisions. Right?
This is, respectfully, Your Honor, the order goes further than just saying it's political gamesmanship. There's quotes that extend to, he's not sufficiently allayed the concerns regarding potential bad faith. That's on page...
Pick any statement you want from this opinion and just imagine that it had been made in the final order dismissing the underlying case. That wouldn't be appealable by the lawyer.
The final order is, finally, it resolves all the issues in the case. And it's not just an appeal from allegations of criticism. There's allegations of misconduct, which the local rules have a special procedure. When the judge feels that there's reason that a conduct gives rise to an investigation or a rule violation, the judge may refer it by separate letter. That
right.
process.
But you're shifting now, that analysis shifts the focus from adjudicating the underlying case, which is done, to initiation of disciplinary proceedings, which is just getting started.
Which the nature in which the district court employed, the case had been closed and dismissed, and then the district court ordered plaintiff's counsel to show cause. Continuing the litigation, holding a public proceeding, Mr. Cardall did not have an option to respond to that order. He was ordered to show cause, and he did. He filed his response supported by expert opinions, and then the district court could have, at that point, said, it's not sufficiently allayed my concerns in a one-word order, and referred it separately to the committee on grievances. Instead, the district court goes on for 4 pages, and in sometimes not the same arguments that were presented previously that Mr. Cardall could address, setting forth his allegations of misconduct.
But the district court
still haven't responded to the point amicus makes, and that I asked you at the beginning, that that's exactly the way many proceedings are initiated, and those orders initiating further proceedings are not appealable. They're not final orders. Even orders that accuse the entity of wrongdoing. And they're not appealable because the question of the entity's culpability is still to be litigated in the administrative. And I mean, that's amicus's major point, and I just have not heard a response from you about why this case is different. You know, what's ironic here, and the reason I asked you about the letter, is that if the letter had never been sent, then we might have a different case here. Although I would think if he never sent the letter, your obligation would be to go back to the district judge and ask him to vacate this order. But we have to assume it has been sent, and so I still haven't heard a basis for distinguishing this case from the thousands of other initiation of administrative proceedings that are non-final. I just haven't heard that. What is it?
The order in this case concluded the underlying proceeding, and as set forth in the text of the order.
Concluded what underlying proceedings? It initiated new proceedings.
Respectfully, no, Your Honor. The initiation is the referral, which the district court specifically said would be done by separate letter.
Okay. All right. Okay. Yeah. I hear you. Go ahead. Sorry.
No, I was just going to say, but I didn't understand your client to be a party to what proceeded. In other words, to the extent that this order is addressing something with respect to your client, isn't that a new thing? Your client was a lawyer in the other proceeding, but he wasn't a part of it. So how could you say that this order, which is addressed to your client, is the end of something as opposed to the beginning?
The Committee on Grievances is charged with investigating allegations of rule violations. There's a process that's set forth for the investigation and then ultimately the prosecution and the trial of allegations of misconduct. In this case, the district court is not the final determination of whether or not a rule has been violated.
Do you have any, I see that your time is expiring or has expired. Do you have any thing to say about the sort of standing point, which is the other threshold issue? Is it your position that there is injury in this case from Judge Boasberg's order?
Yes, Your Honor.
And is that the criticism, or what is the injury? He says, I take no position on whether any discipline should be imposed. I am not making the finding about whether these things qualify as unethical behavior. So it's the criticism that creates Article 3 injury in your view?
It's the injury, in fact, to the reputational harm, which includes while the district court does conclude that he takes no position on the rule violations, his order specifically sets forth allegations of political gamesmanship, that it's hard to believe the suit was meant in good faith, and that...
Yes, I know what the allegations are. What I'm asking you is it your position that every critique by a court, whether it's in an order, it's an open court, whatever, qualifies as an Article 3 injury to the extent the court is saying something about the lawyer's conduct or performance?
Your Honor, I can only speak to the case at bar, and in this case, it's undisputed with both us and amicus that Mr. Cardall has standing and has suffered an injury in fact as a result of the order by the district court.
Okay, thank you.
Thank you.
We'll hear from amicus. Mr. Etchemendy.
Thank you, Your Honor. May it please the court.
Good morning.
Matthew Etchemendy, court-appointed amicus curiae. This case presents the question whether this court has jurisdiction to hear an appeal from the district court's determination to refer an attorney to the Committee on Grievances in an order that imposed no sanctions and contained no actual findings of misconduct. Every court to squarely address that question has said no, there is no appellate jurisdiction in such cases. In my view, that's the legally and pragmatically right outcome. The harder question, and one on which the existing case law provides less guidance, is the best doctrinal justification for that result.
Is what?
Oh, the best doctrinal justification for that result.
Why do you say it provides no guidance? I understood that there were courts who squarely chose one doctrinal justification or the other, and many courts that have said that a person in Mr. Cardall's position has no standing.
They do use the word standing. I'm not sure that that's necessarily confined to Article 3 standing. So if you look at the Tiford and Zenti cases, which are the two key cases finding a lack of jurisdiction under these circumstances, they do speak of standing. Those cases, and certainly Tiford came, I think, at a time when the term standing was sometimes used for statutory factors, sometimes for prudential factors.
All right, so we know what it is now. Tell us why you concluded that there's sufficient injury under these circumstances, given the circumstances that you've laid out, to qualify as Article 3 standing.
Yes, Your Honor. So essentially, my argument on injury in fact, the reason why I think Mr. Cardall did suffer an injury in fact, is just the combination of Sullivan and TransUnion. And I will allow that I'm putting quite a lot of weight on TransUnion. So TransUnion said that essentially there's no meaningful distinction between labeling someone a terrorist and labeling someone as a potential terrorist for purposes of Article 3 injury in fact. Had TransUnion not been on the books, I think it would be, quite a difficult question. I'm frankly not aware of other cases directly speaking to that distinction.
Then let's talk about TransUnion, because I do see you putting a lot of weight on it, and I'm not sure I'm totally there. So I think there's a big difference between what is happening in that case. Justice Kavanaugh says that it's highly misleading and inherently damaging, like defamation, to tell someone or to say that the plaintiff's name is on a list of people that the government had concluded was a terrorist or a drug dealer. And in essence, as I read that case, he's saying that alone is really damaging. So whether it turned out to be that the government had actually designated you a terrorist, the difference between saying you're on a list of potential terrorists and you've actually been designated a terrorist, really not that big, and both are damaging. Here, it seems to me that we have something different. The district court expressed concerns about Mr. Cardall's performance. He made it explicit that he was not concluding that he had acted unethically. And so no one could be misled into thinking that the referral meant that he, the relevant government entity, had concluded that Mr. Cardall had behaved unethically, right? So it seems to me that that's really not the same thing. So can you?
Right, and there may not be the same issue about misleading potential members of the audience of this order. I do think for purposes of Article 3 standing, just keep that separate from the merits. We need to assume Mr. Cardall's position on the merits for purposes of evaluating injury. So I think we need to take it for granted that, many of these criticisms were not well-founded.
Yes, but we don't assume that he has the injury. I mean, that's the question of standing.
Oh, of course not.
So as I was trying to think about this, another way to conceptualize it is that if you had a spectrum of harm in this area, with one end being non-defamation but critical comments, and the other end being the kind of defamatory comment that Justice Kavanaugh identifies, hate, something that could subject you to hatred or contempt or ridicule, and then you plotted TransUnion's two comments, the two ideas I talked about, both your name is on a list that the government says are terrorist, people, and the government has actually designated you a terrorist, both fall on one side of the spectrum. Whereas in our case, I have concerns about your ethical behavior seems so far from I have designated you unethical that one could be on one side and one could be on the other. So the fact that TransUnion puts them both together, says the one is basically the same as the other, doesn't tell me what to do in our case with I have some concern.
So I certainly agree. Standing is always a fact-specific inquiry, and there is a distinction between the type of statements at issue here and in TransUnion. If the court were to decide that there were no standing, I suppose it could distinguish TransUnion. I was just convinced that combination of Sullivan, which says that actually having been labeled as a rule violator is sufficient to establish reputational standing. You combine that with, I guess, TransUnion pouring cold water on the distinction between you did X and you may have done X, that it struck me as probably the best outcome to say that there was injury in fact here.
The other,
Go
sorry,
ahead, Judge.
I was gonna, Sullivan, one major difference between Sullivan and this case is the statement in Sullivan was made by the Committee on Grievances at the end of its investigation. So that's a case where the administrative body charged with adjudicating misconduct does its thing and concludes at the end of its process that there was a violation, but no sanction should be imposed. And that seems very different from what we have here, which is it's some combination of either the district court is just concluding merits litigation and makes comments critical about lawyer performance, and or the district court in its capacity as a complainant initiates the disciplinary proceeding. So
Yeah.
Are there any cases finding standing based on just critical statements that are either embedded in the merits opinion or the disciplinary complaint?
No, I'm not aware of any case that has held that there was standing actually to appeal any attorney discipline related order where there was neither an explicit finding of wrongdoing or some kind of tangible sanction.
I mean, it just seems to me a cleaner line. I'm a little worried about an Article 3 line that would turn on how pointed or definite statements were, as opposed to just simply saying these are statements by the judge who's initiating a complaint, and that's not enough.
It certainly could raise line drawing questions. And so I could understand the concern if this court were to address Article 3 standing. Of course, if you agree with my view on finality, that wouldn't be necessary.
Right.
Speaking, were you done, Judge Katsas?
Yes,
Sorry.
thank you.
Speaking of your view about finality, you also argue that the decision is not a judicial act. You have any view about anything you can share with us about your view about which is the sounder basis for this court to rest a no jurisdiction decision on?
Well, I think they're both sound, Your Honor. I would say certainly the case law is more extensive on finality.
Right.
On finality or standing? Has any court held non-final in this context?
Well, there's a suggestion of it in Teford. So Teford does cite finality case law and says this is analogous to an order to show cause. That wouldn't be appealable because it would be non-final. Teford didn't spell out the 1291 reasoning that I've offered, but finality was certainly one of the things that was on the court's mind in that case. I wouldn't describe it as fully embracing the view that I've put out here.
I'm sorry to cut you off. I just thought there were cases that actually held no standing in this context where there had been no actual finding or.
They did hold no standing, Your Honor.
So we have no standing cases. Do we have a similar no finality case that go through this is a judicial order and all of the factors that relate to finality?
No, there's a thread of that in Teford, but the reasoning isn't fully spelled out.
Do you think there's any doubt that this is not a final order?
I have no doubts, particularly. I do think that the analogy to the agency case law that you mentioned, Judge Tatel, is very illuminating.
Yeah.
Of course, those are different statutes. Those aren't under 1291. But the analogy is fairly strong, and I do think that essentially what the district court was doing here was taking an act that in some respects one sees more commonly with administrative agencies. There aren't very many circumstances in which district courts are initiating complaints.
Right.
But that's exactly what happened here. And we do know how that's treated in the agency context. There's no final appealable agency action.
Would we have to go through the finality factors, and what would we do with the judicial role factor that Judge Tatel mentioned earlier? I mean, this is a civil case. The orders arising out of it. It involved an attorney in the case. It was a resolution to some extent of the order to show cause, at least. It involved determinations that, at least he talks about, sort of merit-related determinations, the kinds of things the grievance board is going to have to consider. So I'm a little concerned about the suggestion that this is not a judicial order, especially given some of the more recent statements of the Supreme Court in the case Iestis versus Davis. I don't know, you may be familiar with that one. So how do we call this a non-judicial order in light of that case?
So just as a matter of clarification, I would say not necessarily that it's not a judicial order, but that it's not a judicial decision. And essentially, the basis of my argument is that this wasn't adjudicating any legal issues. It's hard to see what rights or duties are decided in this opinion. The order has some prospective effect in the sense that it does set in motion a further proceeding, but that's something that any member of the public can do. So I don't see the district court as doing anything uniquely within its judicial power. And my best analogous cases are probably the cases dealing with recommendations, non-binding recommendations made to the Bureau of Prisons. I cite the McHugh case from the Seventh Circuit and the Pinheiro case from the Second Circuit, but there are others out there. And those courts were dealing with attempts to appeal non-binding recommendations that sentencing judges made, essentially, and was held that those were not decisions within the scope of the statute.
So you don't think that the judge's insight into the proceedings is in some ways uniquely different than someone on the street in terms of making the referral?
Well, as a practical matter, I'm sure that some audiences would give it more weight. I'm not sure that's enough to convert it into a judicial decision in the proper sense. The same is probably true in the Bureau of Prisons recommendation cases. I take it that the government takes the judge's recommendation quite seriously. But the fact of the matter is that it remains non-binding. I mean, that's very clear. The committee doesn't have to follow anything in this order.
I want to make sure I didn't read your brief as saying we had to decide that. Isn't your position that finality, whatever this is, it's not final, right?
Yes, Your Honor. So finality is an independent sufficient.
Yes.
You have, in other words, you have standing arguments, and then within 1291, you have two subsidiary arguments. One is judicial decision and one is no finality.
Correct. And since to fit the statute, it would need to be a final decision, both final and the decision, thus are independent basic.
Okay, thank you. Ms. Shore, you were out of time, but we'll give you 2 minutes.
Thank you, Your Honor. The order is a final judicial decision. A member of the public cannot order an attorney in a case to show cause why he should not be referred to the Committee on Grievances and then adjudicate the sufficiency of his response and issue an order. It's not comparable to a layperson submitting a complaint of alleged misconduct separately to the Committee on Grievances.
Anything else? Is that it?
I'm sorry, Your Honor.
Anything else? Do you have
I'm sorry.
Do you have anything else?
Yes, Your Honor.
Oh, go
I
ahead.
respectfully request that this court follow the precedent set by the Third Circuit in Adams, that the district court's failure to follow the local rules regarding the procedure for referrals to the Committee on Grievances and is abuse of discretion. And we respectfully request that this court vacate the order as it was an abuse of the district court's discretion.
Thank you. Mr. Etchemendy, the court appointed you as amicus, and your brief and oral argument have been helpful, and we are grateful for your assistance. Thank you. And thank you, Ms. Shore. The case is submitted.
Thank you.
Case number 20-1493, DTE Electric Company et al. Petitioners versus Federal Energy Regulatory Commission. Mr. Wolf for the petitioners, Ms. Pasella for the respondents, Ms. Valley for the intervener.
Mr. Wolf?
Good morning, Your Honors. May it please the Court, I'm Eric Wolf for petitioners. I really appreciate being able to be with you in person here today. This is about discrimination in electric storage regulation, discrimination without adequate explanation as to its reasonableness, and without adequate explanation as to how it fits within FERC's past policy statements. So I realize in going through the briefing to prepare for this, that to some extent the parties kind of talk past each other on some of the background issues. And so I kind of like to step back a little bit, give some of that background, and then get right into the discrimination that's occurring and why we don't think it's adequately explained or justified. So, as you know, the world of the electric grid, going back to the 1990s, is divided between generation and transmission. And on the transmission side, these are the old local monopolies, wires, transformers, things like that. They get those regulated rates They get a guaranteed rate of return. On the generation side, they now have to, have market pricing. More competition should be better for consumers. Everybody agrees that that's the basic breakdown. That's the basic policy. And everybody agrees that electric storage sits in between that. So if you have a battery, it can put power onto the grid, like generation. You can also take power off the grid, like a wire. So it sits in between. So how do you regulate it? And the other thing about electric storage is it's important. It's a developing technology, and it's particularly significant for alternative energy because you have power generated by wind or solar or something like that. If you have better batteries, if you have better storage, then those alternative energy sources become a lot more feasible. You can get their power into the grid. So it's very important to get this right. So what we have here, mid-continent, Alberta to Louisiana, the operator is allowing these storage projects by the old local monopolies to get those transmission regulated rates, guaranteed rate of return. Now, here's how it's discriminatory, and this is where I think the parties...
Can I just interrupt? This is very helpful, what you're doing. Thank you, but could you just explain to me, so Mid-Continent's done that on the theory that a battery could be used for either transmission or generation, correct? In other words, you could use it either way. Is that right?
Well, here, what they're doing is they're saying that the transmission owners can put in, and I'll just say battery because it's easier to think of it as a battery, can put in a battery, and if it's transmission only, then they can get that transmission rate, guaranteed rate of return, to cover all their costs on that.
Right.
And that is discriminatory because the transmission owners have a right of first refusal on those projects. So
not as a result of this particular plan. That was the pre-existing background rule, right?
Correct. That's a pre-existing tariff. So that tariff actually, that went up to the Seventh Circuit. And just candidly, Your Honors, I wish we'd put more of the Seventh Circuit opinion in here because it is helpful background. What they did in that FERC order said, for the larger transmission projects, those are going to be subject to competition. But for what are called baseline reliability, the transmission owners, the old local monopolists, they have a right of first refusal. And as Judge Posner explains in that opinion, they're always going to do these projects because they know they can recover their costs. They know they can get the rate of return. So that was with respect to just transmission, like old transmission, like wires. Okay. So what happened here is that the transmission owners and the operator, MISO, they said, well, we're just going to treat these storage projects, if they're helping transmission, we're just going to treat them like wires. And maybe there's some explanation that can satisfy that, but they're not wires.
The preference for incumbent transmission owners it's not simply in this tariff, it's baked into Order 1000 itself, right?
Yeah, you can think about it that way, but it's baked in there. That's basically old transmission. I mean, that's wires. That's what that's about.
And one of the conditions in this case, one of the conditions for the storage entity to be treated as to be regulated on the transmission side rather than the generator side is that the project has to meet an identified transmission need.
Correct.
See,
so if the storage facility is functioning as a transmission facility, if it's meeting a transmission need, it's treated as a transmission facility.
We're not
about that.
We're not challenging that you can have one of these projects and treat it as a transmission. That's not our challenge. Our challenge is you can't allow the transmission owners who have this right of first refusal on these projects, these very projects, baseline reliability, when they're going to use storage, they need to explain why you can let them have that competitive advantage. These are the local monopolies.
Going back to Judge Jackson's first point, that's baked into the system that MISO has grafted this onto. That's part of the system. The right of first refusal.
Correct.
And since you're not arguing that batteries can't be used for transmission, I don't see why that issue is even raised.
Well, it's being raised because, I mean, this is at Section 205 filing.
Yeah.
So they come forward, they are discriminating. So they have given a competitive advantage to the transmission owners. You got this new thing called storage.
But that's a pre-existing competitive advantage.
Not for storage. Not for storage.
That's true.
So now, like, we have rules for transmission. Then we have a question whether we're going to treat storage as transmission.
But why does the right of first refusal create a problem for battery storage and not for other forms of transmission?
Well, creating the problem for battery storage gets into the separate policies related to storage and the fact that storage is generation. And FERC wants competition on the generation side. And in the past 10 years, FERC has been very sensitive about how to treat storage because it can generate. It puts power into the system.
Right, but the cost recovery piece of this, which I think is what you're worried about, only applies when it's being used for transmission, right? In other words,
you're right. You're right.
So even though it has the capacity, the battery you're talking about, the storage facility you're talking about, has the capacity to be used either way, transmission or generation. It sounds as though you're okay with the overall determination that it can be used for transmission, but you don't want them to have the legal pre-existing benefits that go with use as transmission.
Absolutely. Absolutely.
I don't understand why that's the case, because if you accept that they can use this as transmission, then why don't they get all of the other benefits that go with use as transmission that the wires get?
Because they're not competing, and they could compete. And we know there's competition on the storage side. And so all we're saying is, if you're going to let storage projects qualify for those transmission rates, you cannot
treat them the
privilege
same
the incumbents.
You cannot treat them the same as the wires with respect to transmission.
Correct, because they're different. Because they're different.
Why are they different? That's what I don't understand.
Yes.
Because they put
That's
power
why I asked you that question right at the beginning. Why are they different?
So they're technologically different.
They're what? Yeah, I know. But in terms of their function, they're well, you go ahead. I'm sorry.
Well, so FERC has recognized this in other cases. There's reference in the briefing to the American Electric Power case. Yeah. Because it puts power into the system. And this is why one of the commissioners dissented. So there's that technological difference. But it essentially functions as a generator. It's not just a wire. And in this particular situation, they are allowing the incumbents to oversize these storage projects. So baseline reliability might be a relatively small project, but they're going to put in.
But they can't use it for generation.
They can't use it yet.
Well, but so yet is the key thing. I mean,
right.
That issue is not before us.
But the competitive advantage here is significant. So they have this process for the old kind of transmission projects, wires, and they just put this into that line, and then they put everybody else into what they call generation interconnection. That's a different line, and nobody disputes that line is more onerous. It's going to take longer, and it is not realistic to say, well, maybe you could come through that project or that line, and what you have to offer in the marketplace, it could come in that door. It will never come in that door. They have given this to the local monopolies, and that's something that for 25 years FERC has been suspicious of. And the Seventh Circuit's opinion is quite good on why we should be suspicious of the local monopolists, because they're always going to reach for these things. They're always going to want to find ways to increase their footprint and to leverage their local monopoly. And so this is a 205 filing. it is their burden to explain why they should be able to discriminate in this way and why it's consistent with past policy. And to just treat this as if it's wires, to not recognize the distinction with storage being generation, to not recognize that there's competition in storage.
Wouldn't your, Mr. Wolf, wouldn't your solution create just a different form of discrimination? In other words, you would be treating batteries used for transmission differently than other transmission facilities because the batteries wouldn't carry with them this right of first refusal. So you would just have the transmission owners claiming discrimination, wouldn't you?
I don't know how they could claim that because it would just be in the technology, not the party. So we want equal.
No, I understand the technology is different. I get that. But if the battery is being used for transmission, does it make a difference? In other words, transmission's transmission, whether it's by wire or through a battery. And I didn't hear you arguing that batteries can't perform a transmission function.
But anybody's batteries could, Your Honor. That's right. The critical thing.
Yeah, all batteries.
We just want equal access. And
okay, all right.
I'll come back to you on rebuttal unless you want.
No, did you have anything else? Anything else? Okay,
well, you had other arguments. So discrimination, again, one. You said something about failing to consider alternatives in a way.
Yeah. So let me speak to that very, very briefly, Your Honor. The only real explanation that they really kind of have two explanations that they offer. One is you can't go there because the right of first refusal is baked in, and we're just going to keep it and treat this as if it were a wires project. And that doesn't adequately explain how you're treating this new technology where you've preferred the marketplace. But the other is the potential competitors who might create that competition, lower prices to consumers. Well, they're not part of the operator's agreement. And on that, they don't explain why you couldn't just have an agreement with an entrant. And there's not much to say on that because they literally have no explanation of why you couldn't just have an agreement with an entrant. The operator's agreement.
Do they have an obligation under this regulatory scheme to consider alternatives? I thought that was their argument. What, are they wrong about that?
They will consider alternatives among how to deal with a transmission problem. So they identify a transmission problem. They'll look at alternative ways to do it. Storage might be one way to fix it. You do have from the incumbents in their intervention brief, you have these sort of sweeping statements that like, well, it's available on equal terms and things like that. That's very artful because, you could submit, a non-incumbent could submit some idea, some proposal, but given the right of first refusal, and again, the Seventh Circuit's opinion is very good on this. Given the right of first refusal, the incumbent's going to do it every time. They get a guaranteed rate of return. So that you sort of can equally, to say, oh, you can equally propose something that's not realistic, that's not pragmatic. And our side are the non-incumbents who can compete for these projects, who just want equal access and don't want to have to go to a separate line that's going to take longer, it's got more cumbersome review, and they have to justify that discrimination.
Oh, I'm sorry, it sounds like this alternatives point is the same as your discrimination point. Is that really all we're talking about here?
I think it all kind of comes together.
It all comes down to that. Yeah. Okay.
Okay.
Thank you.
Thank you. We'll hear from FERC.
Morning, Your Honors. Beth Casella for the Commission. I'll start off with the point on the right of first refusal. So as the court seems to understand, the right of first refusal doesn't come from these orders. The right of first refusal comes from Order 1000 and also from specific FERC orders approving the right of first refusal for the baseline reliability projects that was not only approved by FERC, but also approved by the Seventh Circuit. So What?
All right, but I hear him saying at a very baseline level, although that was the existing state of affairs with respect to the right of first refusal for transmission projects, we now have this new technology, and FERC has essentially allowed for the right of first refusal and incumbents to monopolize this new frontier because MISO has set the plan up in this way. So can you speak to why the plan is failed from a discrimination standpoint, not in the particulars of right of first refusal, but sort of conceptually? Why is the MISO plan acceptable from a discrimination standpoint at that level?
Well, because entities that are eligible under these criteria to become to serve as transmission to satisfy a transmission need are not similarly situated, Your Honor, to entities that are not. So when you, for example, if you look at the tariff provision FF in attachment FF section 2G1C1B, which is at JA 266, which is the requirement that a transmission-only asset, you can't be a transmission-only asset if you could serve the transmission need as a generation asset through your through the markets. So if an entity, if a storage, if a battery, for example.
Excuse me, will you just explain what you just said?
Yes.
Please.
So what that means is what the, as the commission explained in the second order at JA 723, paragraph 29, Mid-Continent will evaluate a proposed transmission-only asset, both as a transmission solution and as a market resource. And if it can satisfy the transmission need as a market resource, which means it's acting as generation, it cannot be a transmission-only asset, and it will not get cost recovery or a right of first refusal or anything like that. None of that will apply.
Okay, but
only
if it does qualify as a transmission only option, then let's go back to Judge Jackson's question, which is that part of the market, this huge new technology in our country for
I'm sorry, I'm having trouble hearing you.
I'm sorry.
That's all right.
We're all getting used to this new world here. They couldn't hear me even before mask, so I put some mask. So the point is that the argument they're making is that with this major new important technology, with respect to batteries that can only perform the transmission function through transmission, the right of first refusal allows the traditional transmission system to monopolize that market. It's anti-competitive.
I'm sorry, I missed the last part.
It's anti-competitive. It allows the incumbent transmission operators.
So that brings me back to
in other words, you'll never have. Why would you ever have in other words, if a battery can qualify as transmission only, why would it ever be offered by a non-incumbent? Wouldn't the incumbents always exercise the right of first refusal?
Well, it's not always going to be true. The commission did say it's most likely to be a baseline reliability project. So it is possible that there could be another project. The commission did not foreclose that. But for purposes of discussion, I'm happy to assume it would only be that.
Yeah.
Because that's, the scenario that the petitioner is interested in. And so let me bring you to what the commission said in Order 1000. The commission said there, it directed transmission providers to remove rights of first refusal for only certain types of projects, not for all of them. Reliability, local projects are not included. And the reason for that is, as the Seventh Circuit explained in approving the baseline reliability project right of first refusal here for Mid-Continent, it said, FERC's justification for this departure from the order's emphasis on promoting competition is the benefit, which is surely very considerable, of a quick resolution of reliability problems. So the commission absolutely in Order 1000 was promoting competition, but it understood that with certain types of projects, here reliability projects, it's too important to ensure quick resolution of reliability. That opinion.
Can I just sort of state back what I think I hear you saying, and you can tell me if I have gotten it?
Yes, Your Honor.
The reason why this isn't a market monopoly and competition problem is that we only get to this world of storage as transmission and the incumbents getting the first right of first refusal after we have evaluated all other possibilities for solving the problem.
That's exactly right, Your Honor.
So the other folks, the new folks, if they've got a better solution before we get to, okay, we've really got to deal with this, guys, right? Then they can come in the market on the front end because we're looking at all options first.
That's exactly right.
Only after we've taken care of all other options do we then look at this. Now we've got to really do something about it, and we're going to give the incumbent the right of first refusal.
That's exactly right.
Is that right?
That is exactly right. And as the commission explained in the second order at a number of places, if either a traditional type of wires transmission solution is equally able to deal with the transmission need, they will choose the traditional wire solution. If a non-transmission alternative is equally able as a transmission-only asset to satisfy the transmission need by displacing the need for transmission, then that will be chosen. The non-transmission alternative will be chosen. So this is really a last resort thing, and the record also shows that the Mid-Continent fully expects this to be a very, very rare circumstance, particularly because it's only going to apply for these very extreme circumstances, an N2 contingency or a stability issue. If it's just an N1 regular thing that can be done through congestion management, a transmission-only asset cannot be approved. So it's a very limited circumstance. The non-transmission alternatives Commission explained will be considered exactly as before. There's no change here. So if petitioner were right that they'll never get through the generation interconnection process to be able to be considered, that's true for any generation. The generation interconnection process takes as long. That's not because of these orders, just like the concern about the right of first refusal. These orders do not change that. Transmission is treated as transmission under these orders, and it is not, those are similarly situated, and it would cause an undue discrimination problem if the Commission treated transmission differently from transmission here. And the generation is not the same as transmission, and storage in the markets is generation. It is not transmission. On the point about alternatives to the transmission owners agreement, I mean, the case law is very clear on this point. In El Paso Natural Gas, 966 F 3rd at 857 and 864, this court explained, and I said this in my brief, the Commission has to accept a rate proposal if it finds it just and reasonable, regardless of whether there are alternative proposals that might also be just and reasonable. Right. So once the Commission determined that Mid-Continent's proposal was just and reasonable, it did not have the opportunity, didn't have the option, even if it wanted to say, maybe there's some other type of contract that Mid-Continent could come up with. As the Commission found, there's already a contract that exists. It's the foundation of the Mid-Continent system in the first place. And that's what ensures that projects will be constructed if they're needed for reliability, and it ensures that functional control will be transferred over to the to Mid-Continent so that it can run the system fairly, securely, and reliably.
I'll ask you a question, though, about the alternatives point, because, I mean, it seems pretty straightforward in the way that you put it, but then we also have, under the APA, the requirement that an agency provides a sufficient response to concerns that are raised about the determination.
That's right, you're right.
And so when you have a situation like this one, if the interested party says in their comments to you as you're reviewing this, here are all the other feasible ways. This person is saying this in the contract. What about this kind of contract? What do you view as FERC's role in actually evaluating the proposal that they put forward? Like, how do you deal with those two different duties?
Yes, I hear you, Your Honor. Let me first say, no type of contract was proposed here, and that's just a side point.
Okay,
They were just like, Mid-Continent can come up with some other kind of contract.
I see.
So that's my first point. But secondarily, in the usual circumstance, and there's, of course, the commission has to consider alternatives to in other kinds of cases. But here, where the commission is not allowed to consider, this is the commission's answer to their alternatives point. We can't even look at it. We just can't look at it. It's not a situation where the commission has the option to say, oh, which one do we like better? The commission is bound to accept a Section 205 proposal if it finds it just and reasonable. And it just doesn't have the option. So it could, I guess, have spent time writing some dicta on why that isn't a plausible answer, but that would just be dicta, and it certainly isn't necessary to satisfy the APA obligation here.
Ask you one other question that might take us a little far afield. I know you just have a little bit of time left. Could you explain, sort of as a practical matter, how a storage facility serves a transmission role? What does that mean to have decided?
Well, here, I can answer that very specifically. Here we know, and again, as I was explaining before, when someone proposes to be a transmission-only asset, the system operator doesn't just take their word for it. They test it. They analyze it. If you're acting in the market, this is what would happen to satisfy this transmission need. And if you can satisfy that transmission need, then that's the end of the story, and you don't go any farther. But they also test it as transmission, which, and the key here is the difference between N1 and N2 contingencies. So the market works, and my co-counsel here probably understands this better, but my understanding of it is the market works that it does, there are contingencies that you can do congestion management with generation and say, I guess we want to have you run some additional generation in now, or we can have you pull some don't run your generation now, to kind of, that's the normal scenario, non-emergency situations. But when you get to an emergency situation, they just don't have the capability. It's just not done in the market. It just doesn't work that way. So when you get to an N2 contingency or a stability issue, those are items that cannot be addressed through the market, period. That's what makes this a transmission issue.
And then you bring in the batteries.
You bring in the battery to act as transmission under the system operator's control is a big important part of that as well, that it can only be done under the system operator's control.
How does the term voltage support fit into what, two terms, voltage support and thermal overload? Are those critical terms for this distinction?
I hate to say that I don't, because that wasn't fleshed out in the record here. It's just part of the commission's precedent regarding that in the Western Grid case. Those were the specific items talked about, but it really wasn't fleshed out, and I apologize. I don't.
That's okay, but so just to pursue Judge Jackson's question, what is it about the particular? Can you give us an example of a situation where a battery is appropriate for transmission?
I just go back to the same point that that the commission addressed and is in the record here, and that's why the commission had the Mid-Continent add this to their tariff provisions, that a transmission-only asset will only be approved if it is needed to satisfy an N2 contingency or a stability problem.
Okay.
And I'm sorry, I just don't have any more information.
That's actually helpful. Thank you.
There's nothing further?
Anything else? Okay. Well, we'll hear from the intervener then.
Thank you, Your Honor.
Thank you.
May it please the court, I am Carrie Valley, appearing on behalf of interveners for
You're going to have to speak up. I'm sorry.
And I can take this off. I took the.
If you would like to,
Okay.
yes.
Thank you. May it please the court, I am Carrie Valley, appearing on behalf of interveners for respondent FERC. And I'll start by addressing the questions that the court was just asking. in terms of how does this serve that function. And it is in that unique circumstance. It is not that initial market congestion issue. It is not an N-0 or N-1. It is beyond that, where this is uniquely situated. And I think that probably the best way to describe it is even just to refer to the court to the record elements that addressed it. We have one project, it's the Wapaka project that was approved. We discussed that at length in JA 618 to 619. We also addressed those unique circumstances.
Could you just tell us what that project is? Just explain it, give us 3 sentences.
It is a 2.5 megawatt battery located in an area that essentially reduces the contingency for unintended load loss under multiple contingencies. And so rather than, if it wasn't there, you'd have to address it through an operational issue that could result in load loss and radializing, which is segmenting those loads. And to avoid that, this battery can avoid that issue by serving as a transmission function. There are other sort of resources that do these sorts of actions as well in terms of voltage support, avoiding load loss. And this is uniquely situated to address that here. And getting back to some of the court's questions about how this works, how is it selected as the unique circumstance or solution, and how that fits into the project categories. So the Mid-Continent has an annual expansion planning process. It lasts 18 months. What is first identified is the transmission issue that needs to be resolved, and then the possible solutions for it. And multiple parties and stakeholders can present possible solutions. Mid-Continent's role is to identify the preferred solution. Once that preferred solution is identified, then the project classification attaches. So whatever that is, once the solution is there, then we looked at the project criteria to determine how it will be allocated and where the construction obligation attaches.
So at what point in the process that you just identified is the determination that we need storage as transmission? Is it in that last step, or is it as part of what is the solution?
It is part of what is the solution. So when we are identifying whether it is the preferred solution to address a transmission issue, it is evaluated independent of project classification, solely whether it is the preferred solution.
What is project classification?
That is whether it is a baseline reliability project, other project, or meets that classification for competitive development that exists independent of this market efficiency project or multi-value project. If it landed in one of those project categories, it would be subject to competitive development, just like any other transmission solution that also met that project criteria.
Can I just have one more second on this? So we have a problem, guys, you say at the beginning. Here's the circumstance that we're talking about. Let's hear all the possible solutions. At that point, one of the solutions is storage as transmission as opposed to something else. That's what I heard you say.
Yes.
And if you decide, so in that, but you only get to storage in transmission, I understood, to be the preferred solution after you have looked at other market, right? I mean, so you look first at the other existing kinds of ways to deal with this. And at the last resort, we go to storage as transmission. And then once you're in the storage as transmission, is that when you do regional versus local or whatnot?
Right. So once we identified this is the solution, then we look at the project criteria of how you classify it. Then that will attach at that point, but not at the determination of what the solution is. Right. It's more after the fact of how do you classify it now that we've identified what the preferred solution.
And within that classification, to the extent that you make it a regional thing or a broader thing, there could be market competition.
Yes.
For the storage as transmission in that.
Yes.
At what stage in this process, were you referring to N1 and N2 before? Is that what, huh?
Yes.
N1 and N2?
Yes.
Okay. At what point in the process is a problem cataloged as N2. That is one that can only be solved by transmission.
My understanding is that's part of the overall planning process. What is the solution? How does it get categorized? What are we trying to address? And in this particular circumstance with the Wapaka project, that was what was being addressed. It wasn't that N-1, wasn't N-0, which may be able to be served by something operating as a market resource. It's only in that unique circumstance going beyond that where it needs to operate as transmission only.
Okay, one more question. So once a problem is identified as an N2 problem, then by virtue of the right of first refusal, it's only going to be the only entities that will be able to do that, right, are the incumbent transmission owner, right?
If it doesn't meet the criteria for a market efficiency project or multi-value project.
Okay, got it. Thank you. All right. We took up all your time with our technical questions. Did you want to take one more minute? And did you have one other thing you wanted to say?
Thank you, Your Honor. I think we addressed the critical issues here.
Okay, great. Thank you. Mr. Wolf, I think you were out of time, but you can have 2 minutes.
Thank you very much, Judge Tatel. I'll just respond to some of what I just heard and also in response to your questions. So we got an explanation from counsel for FERC that was essentially, we think that the Order 1000 rationale for the smaller wires projects, that should apply here. And, so the same right of first refusal, like whatever reasoning supported it in Order 1000, that should apply here as well. They did not say that in the order here. And I think they have to. And it's worth noting, and this is the first 2 pages of the joint appendix, the operator describes what's going on here as a fundamental first step forward and a fundamental shift in their policy. So if this is a fundamental shift, which the operator says that it is, then they need to explain that change. And given the innovation of storage, it deserves an explanation that is not just, well, we're going to do it the same way we do it for these wires projects. On this issue of, we're going to consider everything, and only if we really need it will we do it this way, where the local monopolists are going to get to use it as storage. Because of the insistence on operator control, that runs you right back into, well, you have to be a party to the owner's agreement. So it's not as if they're really considering everything. At the end of the day, they're right back to the local owners. And so it all, the discrimination is still there. It's just, is it adequately explained? We also heard from FERC counsel, well, if we didn't see any other agreements or anything like that, and so we shouldn't have to talk about whether other agreements could satisfy it. That point was raised to them. They should have to respond to it. Was it
raised to them with a specific other alternative contract?
It wasn't raised, as far as I know, and I should be careful here. As far as I know, it wasn't as if, well, here's an agreement, you could use it. But there are lots of other agreements in this field, and their own precedent, Western Grid 2010, was a non-owner of a transmission facility who got a storage transmission project approved. So because of the agreements that they had in place about control. So their own precedent shows how to do it.
All right. Thank you.
Thank you.
Thank you. All the cases submitted. What? Okay. Oh, no, okay.
Case number 20-5356, United States of America versus all assets held at Credit Sui Guernsey Limited, account numbers 41610 and 41950, Sui Guernsey Limited, account numbers 41610 and 41950, in the name of Samantha Limited, as trustees of the Belford Trust, last valued at approximately $147.9 million in United States et al., Pavel Lazarenko appellant. Mr. Stassen for the appellant, Mr. Knoll for the appellee, United States of America.
Good morning.
Good morning.
It's an honor to be here.
Good morning.
Just to start, 2 seconds of background. This is a forfeiture case that with proceedings both in Guernsey and other countries, as well as here in the United States. It's a fairly limited, narrow appeal that we have in front of the court today. And that relates to the restraining order that was entered by the court at the beginning of the case here in the United States, and whether or not that order entered can act as a foreign anti-suit injunction, barring litigation for proceeding in Guernsey. One of the things that's really interesting about this appeal is in the brief filed by the United States in response to our appellate brief, for the very first time, the government admits that if there were independent proceedings in Guernsey, then Mr. Lazarenko would be permitted to litigate in Guernsey. That is on page 38 and 39 of their brief. Well, we were surprised by that admission because it's very clear that there is in fact proceedings in Guernsey.
Could I ask you exactly what has happened in Guernsey in the last 6 years? We know that Lazarenko filed something in Guernsey in 2015 seeking to lift the Guernsey stay. And then we know this anti-suit injunction was generated in the DDC here. But what, if anything, has the Guernsey court done in response to Lazarenko's 2015 filing?
We had correspondence with the Department of Justice regarding the department's view that the filing in Guernsey violated the restraining order. We didn't think it did. Our application filed there. We don't think Guernsey did either because they issued a summons in the case in Guernsey. But we agreed with the Department of Justice that we would ask our lawyer in Guernsey to stay that application, allow us to proceed before the district court to get clarification.
Okay, so it's been stayed at your request.
That's right. We're on hold, waiting.
And how much, can you just tell us at this point how much money is in the Belford Trust?
Yes, it's approximately $180 million.
So can I just ask you, I'm struggling to understand your position as to why you don't think that activity in Guernsey, the kinds of activities that you all undertook, would violate the restraining order.
Yeah, so I think I need to answer that, I have to say that the application that we filed earlier is different than what we would do now. What's been clear is that at some point in time, this case in the United States will come to an end. If the United States gets a judgment, it has to go to Guernsey and try to see if the Guernsey authorities will honor that judgment or to what extent they will enforce it. So the litigation in Guernsey has to go forward at some point. What we would like to do is go to Guernsey and have a determination made under Guernsey law. What is forfeitable under Guernsey law?
Why? Why do you want to do that now?
Because we have to do that anyway. This case is.
But what difference is it? This is abuse of discretion. The district judge says, I hear your motion. I know that you would like to do that, but I'm saying no, let me go ahead and finish my proceeding. So why do you want to do that under these circumstances?
Yeah, I mean, there's sort of
Let me just modify that question slightly, if you don't mind. Why is it an abuse of discretion for the district court to have said no?
I'm sorry, I didn't hear. Why is it abuse of discretion?
Why? It's not, I mean, as Judge Jackson says, it's clear what you want to do. But to prevail here, you have to show that Judge Friedman's denial of your motion was an abuse of discretion, right? So you need to make your argument in those terms.
Yeah, well, we do think it was an abuse of
But why? That's what I want to know. Not just that you disagree with him. Why was it an abuse of discretion for him to decide the case the way he did?
Well,
Because we're not reviewing this de novo. You can't just stand here and make an argument that this is what you want to do and you think it's better. You have to convince us that the district judge abused his discretion in denying your motion.
Well, we would argue it's abuse of discretion when the case law is clear that you can't enter. We have principles of comity here. We also have whether there's a statutory authority.
Well, the government says you waived that. Your statutory argument.
Yeah.
What do you mean? Yeah, they did. That's their argument. They said it's waived, and I didn't see any place in your brief where you really raised it.
Yeah. Well, with regard to waiver, anytime a lawyer sees waiver in a brief, your kind of hair tickles on the back of your neck, and then you realize that's one.
What did you just say?
I said anytime you see the word waiver in a brief, a lawyer gets nervous.
Right.
And of course, I did. And then you see it's just a sentence, and you say, okay, it's just a sentence, but you still want to look at it.
Okay.
And clearly here, at multiple points in time, we raised the specific 983J issue with the district court.
Tell me your best point right now to the place where you think you most clearly raised it for the benefit of the district court.
Sure. The most clear example would be docket number 17. Let me see here. Docket number 741.
Docket 741?
Yes.
And what is it?
We filed after the RJR Nabisco case came down from the Supreme Court, we had a pending motion before the district court regarding specifically the extraterritorial reach of what the district court could do or not do. And the district court said it did not want to issue any rulings regarding extraterritorial reach until after the Supreme Court ruled on RJR Nabisco. That docket number 741 is our specific supplemental brief addressing the extraterritorial reach, or how RJR came down on interpreting statutes and whether or not they have extraterritorial reach. So that issue was clearly raised before the district court. This court ruled it did not.
But I'm sorry, if I look at docket 741, am I going to see arguments about 938J? I thought that's what I guess I'm confused as to.
Yeah, I mean, it came up in various different contexts, but so there's been much litigation in district court regarding what's extraterritorial or not. Which statutes, what can be applied extraterritorially or not. With regard to 983J, we dropped a specific, the court had already ruled on extraterritorial application. We've dropped a specific footnote in our brief regarding the restraining order in which we sort of re-raised the extraterritorial issue.
Okay. So can I get back to the question that I was sort of trying to get at, which is, even if we are deciding whether the district court was right or wrong, sort of in his determination about letting you go, which I take Judge Tatel's point that we're really not doing that, but let's assume we are. What is it that you get out of going back and doing what it is you want to do now? Why are you saying I need to go to Guernsey in this moment?
Yeah, there are two reasons. One is we'd like to be heard on the merits somewhere. That's number one. Number two, the case has been pending for 18 years. This case isn't going to end for years to come. The Guernsey Trust at $180 million isn't growing because it's not a trust. Aren't they managing it? They're not. They're basically getting an interest rate.
Why does the name of the case say 125 million?
Because at some point early in the case, it was invested appropriately as trustees would invest, and they switched, we think, after the restraining order, the trustees. But understand, because of the restraining order, we can't even contact the trustees to say, how are you investing? Can you change your investment? Because
but you don't control that anyway. I thought it was an irrevocable trust. I thought the trustees get to make the decision. So even if you could contact them and say, do it some other way, don't they have the discretion to do what they want?
Two-part answer. One is, under U.S. law, how a trust is titled is not determinative of what kind of trust it actually is. And it's our view, this wasn't so much briefed a little bit, but this is not, we don't think it's actually an irrevocable trust by US law. And the IRS would certainly take the position it's not an irrevocable trust, that Mr. Lazarenko controls this trust based on the way it's set up. So although it's titled irrevocable trust under US law and certainly the way the US taxing authorities view it, it's not irrevocable.
Okay, so if we disagree, let's say we hear your arguments right now as to why you think it's important to allow you to go forward. If we disagree with you, do you lose?
If you disagree with the reasons?
Yeah. If we agree with Judge Friedman and think that's not a good enough reason, are we done here?
I don't think so, because the other issue is the Royal Court of Guernsey. The Royal Court of Guernsey started proceedings. The Royal Court of Guernsey issued a summons. The Royal Court of Guernsey has an ability, or should have an ability, to weigh in on the issues that we've raised in our brief. Was the case started in Guernsey based on misrepresentations? The government says no, we say yes. That's for the Royal Court of Guernsey to determine.
Wait, but why is that an answer to what Judge Jackson just asked? I don't understand that.
I'm sorry?
Why is that an answer to what Judge Jackson just asked you? Maybe I misunderstood you, but
you just gave yet another reason why we should allow you to go to Guernsey, assuming we were making the decision in the first instance.
Right.
I'm asking you if we disagree with you about that, if we don't think giving the Royal Court of Guernsey the opportunity to weigh in on this is important, or allowing you to contact the trustees to make some recommendations about how to handle the trust is important. If we disagree with your argument, is that the essence of your appeal and we're done?
Well, obviously, if the court disagrees with all our arguments, then we would be done.
I guess I'm trying to set up and understand what it is you want us to do. Do you want us to make the determination, or are we looking at whether Judge Friedman abused his discretion in deciding that the arguments you've made right now, he's going to say, no, I'd like to keep going here, and no one touch the money?
Yeah, well, first, we're not asking Judge Friedman's restraining order to be altered at all with regard to, preventing dissipation or any of those things that are in his order. The only thing that we're talking about in this order, it's very limited. They are interpreting any language that in his order, like any other action, to include a foreign anti-suit injunction. So we didn't understand that to be in the order. The Guernsey authorities didn't understand that to be in the order. We filed an application. DOJ says that's a violation. We asked Judge Friedman, can you clarify this? Because we didn't think it was a violation.
he thought it was a violation.
He thought it was a violation.
He didn't think there was any doubt about it.
He thought it was a violation.
Yeah, but I just said he didn't think there was any doubt about it. I mean, his language is pretty strong. He said it's beyond. What did he say? He said it's he says for Lazarenko now to contend that his Guernsey application by which he asked would not affect. He says it strains credulity for Lazarenko to now contend that his Guernsey application, et cetera, strains credulity.
That's right. And that application was a broader in scope. I mean, we weren't asking in that application, first of all, just to get a determination on Guernsey law, what's forfeit under Guernsey law. It was a little broader in the application. That's not what we're asking for now.
Okay, so is it your position that a district judge like Judge Friedman, who has an in rem proceeding before him, cannot issue an order that prevents parties from engaging in litigation that would potentially deplete or do something to the assets that are under consideration in his proceeding? That's your position?
It's It's a little nuanced because what happens here is, regardless of the order of the proceedings, if the proceedings go all the way to judgment here in the United States with no litigation in Guernsey whatsoever, Judge Friedman has the jurisdiction to do that. We're not questioning that. What happens then, as Judge Friedman has said, the effectiveness of that order will be determined in Guernsey by the Guernsey courts when it applies Guernsey law. It's the effectiveness.
Right. He didn't just say that. That's the law. But fine. That means we have to go to Guernsey eventually.
Right.
My question is, an order in the interim that he issued that says you can't go to Guernsey now, why is that abuse of discretion against the law or anything else?
Yeah. Well, first of all, we say it's abuse of discretion against the law because the law is clear about the very restrictive ability to enter a foreign anti-suit injunction. That law is,
Okay, just assume for a moment we think we can figure that one out. Let's assume we agree with the government that it's either waived or you're wrong. Now, continue.
That you agree that it's waived or
that you're wrong, that the district court does have the statutory authority. Now, what's the basis for an abuse of discretion argument?
So the court is ruling that 983J gives the authority to the court to issue an anti-suit injunction.
Yeah, assume we think that's the case.
We probably lose it. We probably lose.
Yeah. Okay, thank you.
Can I ask you a couple of questions about timing? So on the front end of the sequence, the United States went to Guernsey and asked for assistance with regard to property located in Guernsey. And the Guernsey court entered the restraining order. And it said very specifically, any person affected by the order could apply for a discharge. So suppose I think it would have been troubling to prevent Lazarenko from doing that in 2004, 2005, whatever, as permitted by the Guernsey court. That didn't happen. The proceedings in the United States, they went on for a decade. And judge here is in the middle of all that. And then a decade in, Lazarenko says, oh, but now I want to go back to Guernsey mid-proceeding. Why doesn't the comedy analysis change very fundamentally? Well, the Guernsey court says you can come challenge this order if you want. You wouldn't normally understand that to mean, but if you don't, go litigate somewhere else for a decade and then, come back then. That's a very strange notion of comedy.
Yeah, I think it's unclear how the Guernsey court will. We don't know how the Guernsey court will address or react to that delay.
Is there any reason to think that under Guernsey law, a general statement like that saying here's an order and come challenge it if you want means come back a decade later in the middle of litigation elsewhere?
Well, I don't know. I don't want to guess how the Guernsey court will react. The thing that we know is Guernsey court is not familiar or has not been advised as to, for example, how its case started. And it has not had the opportunity to weigh in on Guernsey law, the forfeitability of the assets under Guernsey law, which it has to do at some point.
All right, so let me ask you, so let's go to the back end, but another timing question, which is you want to litigate two issues in Guernsey. One is whether the original 2004 order was procured improperly, and the other is the forfeitability of the trusts under Guernsey law, correct?
Correct.
Is there any reason why you can't litigate those issues at the conclusion of the DDC proceedings in the context of enforcement in Guernsey?
Well, the answer is probably yes. We have witnesses who are dying in this case. We had a primary witness who died in the last few months. The ability to litigate in Guernsey is going to be compromised by more delay.
Did you make that argument to Judge Friedman as he decided whether or not to allow you to go off to Guernsey?
We did make the argument to Judge Friedman regarding, we have a number of dispositive motions pending before Judge Friedman, including the fact that we don't believe the government has admissible evidence to prove its case, the fact that witnesses are dying and have died. All of that is before Judge Friedman, and we have not had rulings yet on those motions.
No, I mean, did you make it in the context of the decision that we're being asked to review today?
I don't think that those specific arguments regarding, witnesses dying, that was not made within the context of the 983J specific motion, no. But it's definitely been before the lower court. He's aware of it and has ruled on it. But the problem we have in this case is it's going to be literally years before this comes to completion. Mr. Lazarenko is not a...
Judge Friedman knew that, right?
Well,
He knew that.
Judge Friedman controls his docket.
Yeah, he knew that, and he denied your motion.
Yes, he denied the motion.
Yeah. Unless either of my colleagues have any other questions.
Just one more. Is the forfeitability of the Guernsey Trust under Guernsey law at issue in the DDC?
Judge Friedman has decided he doesn't want to weigh into that. He's going to wait for the Guernsey court to decide that.
So there won't be a res judicata problem. Your concerns with litigating on the back end are not legal ones about preclusion or not, these arguments not being cognizable in enforcement. They are practical ones about witnesses being unavailable and such.
It's hard to predict. There may be issues for which collateral estoppel or issue preclusion or res judicata apply, but it really depends on how the litigation would go forward in Guernsey, how the Guernsey court would rule.
But the judge here doesn't want to get into the forfeitability issue under Guernsey law.
That's correct.
Okay, that's all I have.
Okay.
Thank you for your time.
Yeah, we'll hear from the government now. Mr. Noel.
Thank you, Judge Tatel, and may it please the court. Andrew Noel on behalf of the United States. Given this morning's presentation, I intend to focus on the merits of Lazarenko's appeal, although I welcome any questions the court might have about the daughter's pending motion to intervene, which we've addressed in our brief. As to the merits of the appeal, the district court acted well within its discretion in maintaining a restraining order in this forfeiture action to preserve the availability of the defendant assets through judgment. That order is expressly authorized in 18 USC section 983J, and continuing the restraint here accords with the statute's text, structure, and purpose. And under these circumstances, where the restraint that Lazarenko seeks to challenge in Guernsey arose only out of and is intended to serve protection of the U.S. action, we don't believe that restraint presents a foreign anti-suit injunction concern. It's not a parallel proceeding. But even if you thought that the precedent relevant to anti-suit injunctions is informative here, we think that the restraining order below is clearly intended to protect the district court's ability to exercise its jurisdiction and serves important U.S. policies.
Why would it have to be a parallel proceeding in order for the anti-suit injunction analysis to apply? I mean, it seems to me that it's at least connected. It's an ancillary kind of thing, and he wants to go now. And Judge Friedman is saying no. So why isn't that the same kind of thing? I mean, right? Why isn't that the same kind of thing?
I understand Your Honor's question, and the best I can describe it is that the concerns that motivate the anti-suit injunction precedent is about preventing a foreign country from exercising its own prescriptive jurisdiction over the same case in controversy, where there's two competing sovereigns seeking to apply their law to resolve a dispute. And that's simply not what we have here, at least with respect to the restraining order. Now, I want to make a specific response to both your question, Judge Jackson, and Judge Katsas' question about why it doesn't make sense to go now to kind of pre-term the enforcement question in Guernsey. And the reason for that is, irrespective of whether the court or the foreign government nation where the property currently sits would enforce this forfeiture judgment to the extent we receive one, that doesn't undermine the validity and importance of the forfeiture judgment, because if, say, Guernsey did not enforce the judgment, as soon as Lazarenko, his daughters, or anyone else moved the funds, say, to the United States, for example, with the actual forfeiture judgment, we could then go enforce it in a U.S. court where the funds now sit. So it's not.
I don't know if that helps you or hurts you with respect to the injunction suit point. In other words, to the extent that a foreign court's judgment concerning this property, these assets in its jurisdiction, has some impact or could have some impact, don't we have the same kinds of comedy concerns that animate the anti-injunction suit, that we don't want another court? We want other courts in other countries to feel comfortable going ahead and allowing people to litigate, even though we are litigating as well.
Yes, Your Honor. And I think that's the reason why we don't dispute that once there is a judgment and there are enforcement proceedings in Guernsey, at that point, to the extent Guernsey law gives Lazarenko an interest to appear there, we don't dispute that he'll be able to do so. What he's trying to do here is to bring arguments about the enforcement or the eventual enforcement to the Guernsey court to lift a restraint that's just freezing the assets in place. He's essentially trying to proxy the enforcement question into the restraint proceeding. And all we're saying is, to the extent that the question is whether the district court abused its discretion in not allowing him to go contest the restraint that's meant to keep the status quo and preserve the assets, that's not an abuse of discretion, and it won't predetermine his ability to contest enforcement in Guernsey, raising the same arguments he wished to raise now at a later point once the district court has determined whether there is a forfeitable property here. And the importance for that is, to the extent that the Guernsey restraint is lifted now, we have real concerns, and I think the district court had real concerns, that Lazarenko could attempt to cause, or the trustees, who are actually the ones restrained, could take some action that could cause dissipation of the assets. And because civil forfeiture depends on the specific identity of the assets, we can't really unwind that at the back end. It's really a concern to make sure that the assets are preserved. Now, I do want to respond to my opposing counsel's point about our claimed change in position, about where we said if there were independent proceedings in Guernsey, we have conceded that he might be able to appear there. What we said in our brief on pages, I think it was 37 and 38, is if there were independent forfeiture proceedings whereby Guernsey as a sovereign was seeking to forfeit the funds to itself, presumably Lazarenko could seek to participate in those. And that's exactly what happened with the Antiguan proceedings, which Judge Friedman considered at the same time he considered the request to modify the injunction as to the Guernsey proceedings, and said, yes, Lazarenko can go to Antigua and can contest Antigua's attempt to forfeit the funds to himself. But to the extent he receives some of those funds in settlement or otherwise gains access to them again, those funds will then still be subject to the U.S. restraining order. And we are not saying that he can't later at the enforcement stage participate, or if there was actually an effort by Guernsey to forfeit the funds to himself, he can't participate. What we're saying is he can't attempt to lift the restraint that exists solely because the Guernsey court has chosen to enforce the restraint that the district court has put in place.
It's interesting because this was sort of my question to him from the beginning, which is that what he's trying to do? Why is he going to Guernsey? Is it because he's attempting to lift the restraint in effect by getting his hands on the assets, or as he suggested at one point or many points in his brief, just to litigate kind of in the ether this idea of whether or not at the end of Judge Friedman's thing, he would be able to get the assets should that be the legal ruling that Judge Friedman gets. You understand what I'm saying?
I do, but I think his arguments as to the latter, as to the fact that he thinks Guernsey wouldn't enforce this judgment, which we dispute, obviously. The Guernsey court has chosen to freeze the assets in light of this case. But if he's correct, he wants to then lift the restraint in the light of the fact that Guernsey would not ultimately enforce the judgment. And we think that raises a real risk of dissipation. Now, as to the other possible arguments, I just heard reference today about why they would seek to go to Guernsey, whether it be because there's an investment issue about how the funds are being managed or the kind of delay and prejudice arguments. Those are not arguments that were brought before the district court here as specific reasons to modify the restraining order. And I would point the court specifically to appendix page 56, where the restraining order says that an individual can't modify or seek to take action that would affect the value or availability of the funds without request to the district court and notice to the government. So it's possible that if Lazarenko's sole concern is, we don't think that the trustees are managing the funds correctly, but we don't want to take them. We just want them to pursue a different strategy. I don't want to prejudge our opinion on that because I think if an aggressive strategy might well affect the value of the funds, but he could certainly ask the district court to consider the possibility that they could bring some type of declaratory judgment action or specific action as to the investment of the funds that would not alter, the value or availability of the funds or raise the same risk of dissipation. So that's just not particularly. If you look at 13 paragraph, I'm sorry, Judge Katsas.
Are you done with that?
I was just going to say, look at 1309. There's a paragraph that says specifically what the modification Lazarenko was asking for that's on appeal here, and he asked to be able to go to Guernsey to attempt to lift the restraint on the Balfour Trust assets, and that's not what he argued.
I'm sorry, what's the citation for that?
Docket 1309, which is the motion to modify the restraining.
Thank you.
What do you do with the fact that the Guernsey court on the front end of the case, it's not enforcement, this is when they enter the freezing order, they say very explicitly that any person affected by this order can apply for a discharge. Isn't it a pretty aggressive intrusion on Guernsey sovereignty for district court in the United States? I mean, this property is in Guernsey. The district court's orders here aren't worth the paper they're printed on unless the United States gets help from Guernsey. They go to Guernsey for the freezing order. The Guernsey court says, yes, we'll freeze the order, but people who don't like that can come back and seek modification. Isn't it an extraordinary intrusion on Guernsey sovereignty for a court in the United States, given all of that, to say, no, you cannot go back and seek to have that order modified?
So I don't think so, Your Honor, for three reasons. And I don't think it presents the type of comity concerns that I understand you to be referencing. And I just say that the district court expressly addressed this in the 2015 order, where this was raised to Judge Friedman specifically, the fact that Guernsey had presented this pro forma order to Lazarenko. And the court said, look, the proceedings in Guernsey are just freezing the assets in service of the U.S. action. And it's not an attempt for Guernsey to exercise its own sovereign authority over these funds. And so the fact that Lazarenko's been offered the opportunity to come contest it doesn't raise a comity concern or affect the district court's ability to, my authority over Lazarenko. And I'd also emphasize that the sorry, go ahead.
But the Guernsey court has decided to cooperate with U.S. enforcement, but subject to this condition. It might be hugely important as a matter of Guernsey due process that someone subject to a freezing order has a day in court or an appeal.
Well, the second point I'd make, Your Honor, is if you look specifically at the Guernsey order, I don't have the site in front of me, but it's in the appendix. Mm-hmm. The order itself only purports to restrict Credit Suisse and Bank Julius Baer, the two banks and custodians. It doesn't actually restrict in any way Lazarenko. Now, we assume that the court sent him the order to say he's, quote, affected by the restraint because he's the individual for whom the underlying conduct is alleged to have been criminal. But I additionally don't think, beyond the comity point I just made, that there's actually kind of prejudice to Lazarenko to the extent the order itself is not imposed against him under Guernsey law.
Yeah, and there's a lot of question about the rights of the settler vis-a-vis the trust, the rights of the beneficiaries vis-a-vis the trust. I get all that, but
and Your Honor, all of that.
I mean, this seems to prevent. There is some person who has the right kind of interest in the trust, whose actions are restrained, who, according to the Guernsey order in 2004, has rights under Guernsey law to come back and challenge that restraining order, but can't do it. Is by the district court.
All I would say is I think the trustees, as the current custodians, may have that right, but the order specifically allows them to continue to invest the funds and otherwise manage the funds so that they are, properly controlled. And as to my knowledge, the trustees have not come to Guernsey and sought to, raise an issue with the restraining order.
And is there any reason to believe that any Guernsey interest in getting this resolved in some way couldn't take place on the back end once the United States in this context is done?
No, Your Honor. I think to the extent the arguments are about whether Guernsey law will recognize the forfeiture judgment here, which is, I think, the essence of Lazarenko's claims, that question will be resolved at the enforcement stage. But again, without a judgment from the U.S. court, there's a risk that the assets can be dissipated before a judgment can be reached here. And that is a concern. But I don't think it prejudices the ability for Guernsey, when it is asked to enforce the judgment, to make a determination under its own sovereign law, whether it recognizes this type of action on these facts in enforcement. But again,
what do you do with what he says in his reply brief? He says, even if he prevails under Guernsey law, in other words, even if he's allowed to proceed under Guernsey law, and I'm quoting, he will still be bound by the restraining order until and unless modified by the district court. That's what he says in his reply brief.
So, Your Honor, we would take two issues with that. I'm not sure the basis for that assumption, because if the district court's order is lifted, I'm not sure what legal basis the district court would have to restrain him. And in particular, if this court were to accept, and this goes to Judge Jackson's argument about the authority, to the extent this court accepts his argument that third parties can never be, that he is a third party, which we dispute, but if third parties can never be restrained by 983J because it's Rule 65, or if where there's foreign assets, notwithstanding 28 USC 1355, which clearly gives jurisdiction over assets held abroad, if a restraint nevertheless functions as an anti-suit injunction. Accepting either of those two arguments, I think, would mean the district court has no authority to restrain Lazarenko here. Yeah. So I don't understand the splicing he tries to do in his reply brief about, you can lift it as to allowing me to go litigate in Guernsey, but I'll still in some other capacity be bound by the district court's restraining order. So unless the court has any other questions, I'm happy to see the
Katsas, you okay? All right. Thank you.
Thank you, Your Honor.
Let's see. Mr. Stassen, you used up all your time. You can have 2 minutes.
Thank you for that indulgence. Real quickly on waiver, the one thing I forgot to mention was 983J was mentioned in our 2016 clarification motion in the reply brief at page 4. I think that last little colloquy is really important because Pavel Lazarenko is in the United States. He is subject to the restraining order that Judge Freeman issued. All of the restraints that are in that restraining order apply to him, including he cannot dissipate, he cannot move the assets, he cannot do anything with those assets. Even if we litigate in Guernsey, and the Guernsey court says under Guernsey law, let's say 50% of the assets are non-forfeitable under Guernsey law. We can't do anything with that. With what we have to do is take that Guernsey order and bring it back to Judge Freeman and say, and then work through the issues of what happens. We're not asking for the entire restraint to be lifted, and Mr. Knoll just implied. That's not what we're asking for. All we're asking is for, in his order where it says any other action, that no party can take any other action that would, diminish the asset, that any other action should not include litigating abroad.
I guess I don't appreciate the distinction that you're trying to make. Yeah. So you seem to be suggesting that you are okay with the part of Judge Friedman's order that says you can't move the assets, take the assets, or anything else. What you're not okay with is the part of Judge Friedman's order that says you can't take any other action to essentially affect that same result. Because to the extent that take any other action means I'm going to keep you from going to Guernsey and letting them give you permission to move, steal, or take the assets, then we've got basically the same thing. It's a distinction without a difference, right?
Except that we're still subject to the U.S. order. So we can't move. Even if Guernsey says we can move it, we can't because we have Judge Friedman's.
But then why go there? This is my very first question.
Yeah.
If you're still restrained, then what difference does it make? Why do you care so much about going to Guernsey?
Judge Friedman may realize, as Judge Katsas said earlier, the judgment he issues is only good. It's just a piece of paper until the Guernsey authorities weigh in. Judge Friedman may want to know that the Guernsey authorities say 20% isn't forfeit under Guernsey law. That may affect the trial.
He says, I don't want to know. You asked him that. He said I don't want to know.
Well, we don't know what the ruling of the Guernsey court would be. That's the problem. We would like to have that. We'd like to have that opportunity. We'd like to give the Guernsey court the opportunity.
All right, so I'll return to my very first question. I understand that, and maybe you're right, but why was it an abuse of discretion for Judge Friedman to say no?
We say it's an abuse of discretion because the interpretation of the order that any other action includes anti-suit is abusive of discretion.
Okay, great. All right. Anything else?
Thank you for your time.
Okay, thank you. The case is submitted.
Thank you.
Stand, please. This honorable court is now adjourned until Friday, December 3rd at 9:30 a.m.